27 of the Constitution. These attempts were Constitution of Kenya Amendments 2010, Amendment Bill 2015, dubbed the Okoa Kenya Initiative, Punguza Mizigo Constitution of Kenya Bill 2019, and more recently, this particular amendment bill that has brought these appeals before us. The first two initiatives failed for not garnering the requisite support at various stages of the amendment process, while the amendment bill was subject to the court process, culminating in the instant appeals. Besides the above three attempts under the popular initiative, there have been more than a dozen other unsuccessful attempts to amend various articles of the Constitution since 2011 through parliamentary initiative route under Article 256. The instant appeals concern the amendment bill, whose genesis can be traced to the outcome of the 2017 presidential elections. Following the initial and repeat presidential elections in 2017, His Excellency Honorable Uhuru Kenyatta, the President and Commander-in-Chief of the Kenya Defense Forces, embarked on uniting a divided nation, which led to the reconciliation famously known as the handshake between Honorable Raila Odinga, the then leader of the opposition coalition, and himself on 9th March 2018. In line with their mutual commitment to create and foster a united Kenya, the President and Honorable Raila Odinga released a joint communique known as Building Bridges to a New Kenya Nation, highlighting 9 problem areas which they deemed as negatively impacting on the peace and unity in the nation. Subsequently, the President established the Building Bridges to Unity Advisory Task Force, BBI Task Force, via the Gazette notice dated 24th May 2018. Its mandate was to evaluate the 9 identified problematic areas and make policy, administrative, and reform proposals that would build lasting unity based on consultation with citizens. Towards that end, on 26 November 2019, the BBI Task Force presented its reports titled Building Bridges to a United Kenya, from a nation of blood ties to a nation of ideals. That report was presented to the President and the Honorable Raila Odinga, which was unveiled to the public the following day on 27th November 2019. Intent on the implementation of the proposals in the BBI Task Force report, the President appointed the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report, via a Gazette notice dated 3rd January 2020. The main objectives of the BBI Steering Committee was to undertake validation of the task force reports with citizens, as well as propose administrative, policy, statutory, or constitutional changes it thought necessary for the implementation of the recommendations contained therein. On completing its mandate, the BBI Steering Committee presented its report, titled The Report of the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force Report. This was done on 21st October 2020. Annexed to the report were a number of documents, including a draft Constitution of Kenya Amendment Bill 2020 and the proposed legislative amendment bills. Somewhere along the line, the draft Constitution of Kenya Amendment Bill 2020 was reviewed, culminating in the amendment bill, which was published by the government printer about a month later on 25th November 2020. Thereafter, the BBI to a United Kenya National Secretariat put in motion the process of correcting signatures in support of the amendment bill. Upon correction of the requisite number of signatures, the BBI National Secretariat submitted the same together with the amendment bill to the Independent Electoral and Boundaries Commission for verification and thereafter submission to the county assemblies and Parliament for approval. This is what brought the litigation. While the amendment process was ongoing, 8 petitions were filed before the High Court challenging the constitutionality of the process, which resulted in the amendment bill and the contents thereof. 7 petitions were consolidated on 21st January 2021, while the 8th was consolidated with the rest on 10th March 2021. Kenya Human Rights Commission and 4 professors, Duncan Ojuang, Osogo Amani, Dr. Rinda Musumba, Jackie Mwimari, were joined as amici curiae, while Kituo Sasheria and Filista Wakesho were also joined as interested parties. Most of the petitions raised more or less similar issues, which are summarized in our judgment. We have summarized what is contained in petition number E282 of 2020, David D. and others versus the Attorney General. We have also summarized the petition by the Kenya National Union of Nurses, the petition by the Third Alliance, Kenya and others, and the steering committee of, versus the steering committee of the BBI. In opposition to those petitions that were filed, the competency of the petition was challenged by the Attorney General, who argued that the issues raised therein were res judicata or sub judice. After hearing the matter, the High Court identified issues for determination, which they duly did, and came up with a judgment which was appealed before the Court of Appeal. Before the Court of Appeal, IBC filed 12 grounds of appeal challenging the High Court's findings, contending that the court had, by finding there was no quorum to undertake the constitutional and statutory mandates. It is also challenged the decision that the court misapprehended the provisions of Article 257(4), which did not require the IBC to verify whether there was public participation before the verification exercise. In the High Court, this appeal was challenged. The Court of Appeal had the appeal and also the cross appeal by the Kenya Union of Nurses and also by OP 254 and the cross appeal by Mr. Murara Omoke. In determining those appeals, the court framed 21 issues which were determined by the conclusions and findings that were pronounced in the read judgment by Musinga J. Those findings are there, I need not read them. And before us now, the Attorney General, the IBC, and the third appellant were dissatisfied and therefore they found these appeals, which were consolidated before us, and we were able to frame 7 issues for our determinations. We also directed parties to file written submissions, which were done, and we have summarized all those submissions in our own judgment. I do not wish to read what each party said in the argument to support the appeal. The appeals were also opposed by the respondents, and we have captured all the submissions in opposition in the judgment. There were parties also who supported the Attorney General and the IEBC's appeal. That is the 13th and the 15th respondents. We have captured what they said. The National Secretariat and the Honorable Raila Amolo Odinga. The appeal was also supported by the President, and we have captured what was submitted before us by Council in our long judgment. The 19th respondent, Isaac Arwoche, appeared in person, relying on his submissions, which we have also highlighted in our own judgment. The 72nd respondent, Perista Wakesho, we have also captured what was said in the submissions. We have highlighted the specific parties who opposed the appeals. Mr. Morara Omoke opposed the appeal, supporting the decision of the High Court. The first, second, third, fourth, and fifth respondents, represented by Mr. Nelson Harvey and Ms. Esther Angawa, also opposed the appeal and relied on their written submissions and made oral submissions, which we have captured in our own judgment. The 7th, 8th, and 9th respondents are represented by Mr. Elias Mutuma, appearing with Ms. Gerono for the 7th to the 8th respondents, also relied on their joint submissions and made oral highlights, which we have captured in great detail in this judgment. The 11th and 12th respondents, represented by Learned Counsel Mr. Elisha Ongoya and Evans Oganda, made submissions in opposition to the appeal. So was Mohori, represented by Ms. Caroline Kituku, made extensive submissions on the issue of the verification of signatures by IEBC and also the quorum of IEBC. We have captured that. The 79th respondent, Kituo Sasheria, represented by Learned Counsel Dr. Kamino, also made extensive submissions, and we also have considered the briefs by the Hamisi, Professor Rosalind Dixon, and Professor David E. Randau, the first and second Hamisi. We have also considered Gautam Bhatia, the third Hamisi, and what he told us in his written submissions. on the application of the basic structure. Professor Migai Akich, the fourth amicus, also submitted his amici brief, which we have summarized on the issues that they raised. Professor Richard Albert, the fifth amici, we have captured the submissions regarding the issue of the basic structure doctrine. And Professor Yaniv Rosnai, the sixth amicus curiae. Professor Charles Manga Forband, Professor Dr. Adem Abebe, Dr. Duncan Ojuang, John Osogo, and Dr. Rinda Musumba also filed a very extensive amici brief with Dr. Jack Mwimari. The Kenya Human Rights Commission also made some extensive submissions on the basic structure doctrine. I have considered all those submissions for and against the appeal, and as observed, the appeals are predicated on Article 163, 4A of the Constitution, which clothes this court with jurisdiction to determine appeals from the Court of Appeal on question of interpretation and application of the Constitution. Although the length and breadth of the pleadings and arguments are summarized, I've touched on several chapters of the Constitution. The common denominator is that they are focused on the interpretation and application of Chapter 16 of the Constitution and how that is to be done. The two superior courts below have traversed and touched all the key provisions of the Constitution. In my view, therefore, this court's jurisdiction is properly seized under that provision of the Constitution. And having set out the issues framed by the court for determination, the 7 issues, I will now proceed to deal with them sequentially. On the basic structure, it is pertinent in the circumstances to point out that the basic structure doctrine, as articulated in the High Court and endorsed by the majority judgment of the Court of Appeal, the sum total of the two decisions being that beyond the 3 stipulated pathways for amending the Constitution provided in Chapter 16, there are certain fundamental features in the 18 chapters of the Constitution that are not amendable without first determining on a case-by-case basis whether a proposed amendment forms part of the basic structure. Further, that any amendment to these particular articles identified as fundamental features of the Constitution would follow a 4-sequential process, being civic education, public participation, and collection of views, constituent assembly debates, and a referendum. In effect, the two superior courts below concluded that certain provisions of the Constitution are beyond the reach of enumerated amendment powers stipulated in Chapter 16 of the Constitution. The history of the emergence and evolution of the basic structure doctrine was comprehensively covered in the very detailed judgments of the two courts below. Therefore, I will merely mention some of the key features to place my findings in perspective. The basic structure doctrine first received judicial recognition in 1973 in the Kesavananda case, a decision of the Supreme Court of India. The case concerned a challenge to the state government of Kerala's attempt under 2 Land Reform Acts to allow state government to acquire privately owned land to fulfill its socio-economic obligations. Subsequently, the Indian Parliament passed the 24th, 25th, and 29th amendments to the Indian Constitution, which in one way or the other shielded Kerala State's Land Reform Acts from being challenged in court. It is in this context that the Supreme Court of India addressed the question of whether there were limits to Parliament's power to amend the Constitution. In a majority judgment of 7 judges with 6 judges dissenting, the Supreme Court of India held that the 24th, 25th, and 29th Constitutional Amendment Acts passed by Parliament, exercising its powers under Article 368 of the Constitution of India, were unconstitutional to the extent that they damaged the basic structure of the Constitution. The doctrine places substantive limits on the amendment power by placing the basic features of the Constitution beyond the legislative's power to amend the Constitution. In effect, the Supreme Court of India endorsed the idea that a constitutional amendment can be unconstitutional on substantive grounds. I have recited or restated the provisions of Article 368 of the Indian Constitution. And from that provision, it is clear from its reading that the amendment process under the Constitution of India is exclusively vested in the legislature. This therefore means the amendment process of India's Constitution can be described as falling under the flexible model of amendment powers in the flexible regime dichotomy used to categorize the nature of amendment powers in a given constitution. And for this preposition, I have also read the books by Zachary Ekins and Richard Albert on making, breaking, and changing the constitutions. Subsequently, the basic structure doctrine and the idea of limits of power to amend a constitution have been considered by courts in several jurisdictions across the world and received mixed reception. For example, the basic structure doctrine and its various variants have been accepted in Bangladesh, Belize, Colombia, Taiwan, Malaysia, Slovakia, and Peru. While courts in France, Georgia, South Africa, Singapore, Zambia, Uganda, and Tanzania have rejected the doctrine. What this state of play demonstrates, which has been recognized by some of the distinguished scholars as reflected in the various materials cited before us, is that the basic structure doctrine has not yet matured into a universal norm of constitutionalism. And for that, I've referred to the writings by Richard Albert, Maukas Makize, and Therese O'Key. Given that the basic structure doctrine has not matured into universal norm of constitutionalism or a doctrine of general application, courts have adopted the approach of evaluating its fit within their constitutional systems before accepting its applicability in the various jurisdictions where it has been considered. In Kenyan context, this court has already developed an approach which courts are obligated to follow in ascertaining whether to transplant any juridical idea to the Kenyan Constitution in the post-2010 constitutional order. In the vetting board case, this court grappled with the question of the scope and effect of the ouster of the judicial review power of the High Court by a constitutional ouster clause. Whereas the court considered similar jurisprudence on ouster clauses from other Commonwealth countries that had been inspired by the landmark decision of the House of Lords in the animistic case versus Foreign Compensation Commissions and ANA. This court developed the interpretive model to be followed. In that case, the vetting board. I have considered the dictum in that case and the imposed obligation by this court under Section 3C of the Supreme Court Act, which provides that we must develop rich jurisprudence that respects Kenya's history and traditions and facilitates its socio, economic, and political growth. Accordingly, before declaring the applicability or otherwise of the basic structure doctrine in Kenya's constitutional context, a court is obligated to take into account our constitutional history, especially bearing in mind that the doctrine, which found root in 1973 in India, was available when the framers of the Constitution of Kenya conceptualized the provisions of Chapter 16 on amendments. Another way of looking at the matter is to ask a pertinent question as to whether there are gaps identified in particular in regard to the provisions of Chapter 16 of the Constitution requiring to be sealed by the basic structure doctrine. In addition, in evaluating whether the basic structure doctrine is applicable in our constitutional system, a court must take into account the purposive and value-based interpretation decreed by Articles 10, 20, 4, 159, and 259(1) of the Constitution. Such an approach to constitutional interpretation begins from and remains rooted in the text of the Constitution, whilst interpreting it holistically, giving effect to its values and principles, and never losing sight of the historical context and the backdrop of the provisions being interpreted. Therefore, to comprehend and contextualize whether the Constitution contemplates the basic structure doctrine, the starting point should be the rationale behind the provisions of Chapter 16 as documented in the preparatory documents from the constitution-making process. It is an understatement to say that Kenyan independent constitution endured a legacy of hyper amendments during the post-independent period. The former constitution was flexible, giving the legislative wide power and discretion in amending it. As a result, Parliament undertook so many amendments to the Constitution that it lost its original character. The most significant amendments being the merger of the Senate and the House of Representatives to establish a unicameral legislature, abolition of the quasi-federal regional governments that led to the establishment of a unitary state, and alteration of the entrenched majorities required for constitutional amendment, making it easier to amend the Constitution. Yet another repulsive amendment was the abolition of the security of tenure for judges and other constitutional office holders. Ultimately, the amendment that finally broke the proverbial camel's back, giving rise to the clamor for a new constitutional order, was the one that converted the country from a multi-party democracy to a de jure one-party state in 1982. Informed by this history, Kenyans yearned for a stable constitutional system where the power to amend the Constitution would not be abused for short-term interests by political elite. The CKERC report records at page 74 that Kenyans expressed what they wanted, and I quote, "There is a need to protect the Constitution against indiscriminate amendments." What emerges from the historical account is that there was a strong concern that the country should adopt provisions on amendment power that are able to protect the constitutional order from abusive amendments. But this was not all. There was also a recognition that the Constitution must remain flexible in order to adjust to political, social, economic, technological, and other changes that take place in the polity. In effect, the overarching imperative that informed the drafting of Chapter 16 was the need to find a proper balance between rigidity and flexibility. The quest for a balance between rigidity and flexibility is evident in the tiered amendment provisions in Chapter 16, which stipulates 3 pathways for amending the Constitution. The first pathway, under Article 256, provides for amendment by parliamentary initiative. This process involves public participation and approval by the Houses of Parliament through a vote of endorsement by 2/3 of all members of each House during the second and third reading of the amendment bill. The second pathway, under Article 257, provides for amendment by popular initiative. This process involves collection of at least 1 million signatures from registered voters in support of the popular initiative by the promoters of the initiative. Approval of the initiative by the majority of the county assemblies, and passage of the bill by the majority of the members of each House of Parliament. In this second process, if either House of Parliament fails to pass the bill, the proposed amendment is submitted to the people in a referendum. The third pathway, under Article 255, relates to what has come to be known as the entrenched provisions of the Constitution. Some of the Court of Appeal judges referred to these entrenched provisions as forming the basic structure of the Constitution. Article 255(1) of the Constitution stipulates that in addition to adopting either the parliamentary initiative or popular initiative pathway, where an amendment relates to the following articles, a bill to amend those provisions shall be subjected to a referendum. These are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the national values and principles of governance in Article 10(2), the Bill of Rights, the term of office of the President, the independence of the judiciary and commissions, and independent offices, to which Chapter 15 applies, the functions of Parliament, the objects, principles, and structure of devolved government, or the provisions of Chapter 16 on amendment of the Constitution. Approval through the envisaged referendum under Article 255(2) must satisfy 2 conditions. At least 25% of the registered voters in each of at least a half of the counties should vote in the referendum, and such an amendment should be supported by a simple majority of the citizens. A reading of the 3 pathways for amending the Constitution in Chapter 16 clearly shows that Kenyans were alive to the historical legacy of the culture of hyper amendment in the pre-2010 era and sought to tame any abuse of the amendment power. In particular, Article 255(1) and 2 of the Constitution demonstrates that, alive to the culture of hyper amendments, the Kenyan people sought to ring-fence the core fundamental commitments of the Constitution by entrenching them and subjecting the process of amendment to deepened public participation, as well as imposing a downstream constraint veto by stipulating that the entrenched provisions enumerated in Article 255(1) of the Constitution can only be amended through a referendum process. The rationale of entrenching the provisions mentioned in Article 255(1) of the Constitution is, in my view, informed by the very democratic idea that constitutional amendments of a fundamental nature should take place through a deeply participatory process and be ratified by the people, being the ultimate sovereign of the polity, through a referendum. The approach in balancing flexibility and rigidity in constitutional amendment adopted in Chapter 16 reflects and compares favorably with modern constitutional architecture and design. Drafters of contemporary constitutions pursue the goal of balancing rigidity and flexibility through what has been termed as tiered design amendment rules. This argument is augmented by the articles cited before us by Professor Rosalind Dixon and David Randau in their writing titled Tiered Constitutional Design. Under the tiered constitutional model, amendment rules vary with provisions that are core to fundamental to constitutional systems being placed on a higher tier and made more difficult to amend. The amendment rules under the Constitution adopt this modern tiered constitutional design, combining the virtues of rigidity and flexibility by having different amendment procedures apply to different parts of the Constitution. The core foundational values, principles, and structures of the Constitution have been granted a higher level of entrenchment to ensure the stability of the constitutional system. It follows, therefore, that Kenyans were conscious of the core constitutional values, principles, and structures that they wanted protected from abusive amendments, and they protected them through entrenched provisions in Article 255 of the Constitution. In my view, therefore, the framers of the Constitution were aware of the basic structure of some key features from flexible amendments, and if it was their intention to provide for eternity clauses or the basic structure doctrine, nothing would have stopped them from doing so. The next question that follows is whether it was necessary for the two superior courts to adopt the basic structure doctrine and thereby devise a fourth-way path for amending the Constitution outside the three pathways that are stipulated in Chapter 16. To answer this question requires one to appreciate how the High Court and the majority of the Court of Appeal judges proceeded to analyze Chapter 16. It was on the premise that based on the history of hyper amendments of the repealed Constitution during the pre-2010 dispensation, the Constitution demanded heightened procedures beyond the tiered design of the amendment procedures provided in Chapter 16 that would make the Constitution more difficult to amend. The two courts, therefore, did not go into a detailed analysis and to specifically point out the actual shortcomings of the provisions of Chapter 16, especially in light of all the 21 unsuccessful attempts that have been made over time, over the last 10 years, to amend the Constitution. The Court of Appeal, in my respectful view, and a duty to analyze the findings of the High Court and specifically point out whether there were apparent inadequacies as far as the provisions of Chapter 16 were concerned. Looking at the history, as stated above, as well as the provisions of Chapter 16, it is clear to me that Kenyans sought to achieve a balance between rigidity and flexibility in the amendment process. Kenyans did not want to shift from one extreme of hyper amendment to another extreme where no amendment can take place. That is, from hyper amendment to ultra rigidity in the amendment process. Rather, what Kenyans desired is a balance between rigidity and flexibility, as reflected in the tiered amendment process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened protection, but still open to amendment through an enhanced, inclusive, and participatory process that culminates in our people exercising their sovereign power through ratification in a democratic process in the form of a referendum. The High Court and the majority of the Court of Appeal, with tremendous respect, failed to appreciate that the tiered amendment process is one of the options available in the menu of constitutional designs options for dealing with the practice of abusive amendments, just like other designs options limit amendability. For example, eternity clauses and basic structure doctrine. Therefore, where Kenyans have selected the tiered amendment procedure as their response to the culture of hyper-amendability, I find it difficult to justify this judicially created fourth pathway of amending the Constitution founded on the basic structure doctrine. Unfortunately, there was no justification provided to demonstrate the lacuna in the Constitution and hence the need to call in hand the basic structure doctrine to enhance the existing tools of interpretation. The 2010 history of Kenya is replete with precedents of application of foreign laws and doctrines from Commonwealth and other jurisdictions, which was done due to statutes. Today, I dare say that courtesy of our Constitution, we have sufficient arsenals that include our own canons of interpretation, which we must exhaust before borrowing from other jurisdictions. Further, I see a potential conflict within the constitutional system with the judicially created fourth pathway for amending the Constitution. This is for the simple reason that in our constitutional dispensation that is people-centered, our nascent democracy that respects ours by vesting legislative power in the legislature, to create a fourth pathway within the scheme of amendments would bring into question the place of the participation of the people and the place of the legislature in that scheme. Taking into account where we are at in our constitutional democracy, Kenyans needed to be consulted on whether it is their wish to introduce the fourth pathway for amending the Constitution. In other words, we judges should be vigilant, lest we are accused of usurping the sovereign power vested in the people by introducing a constitutional amendment through judicial fiat. Put differently, the tiered amendment process provided in Chapter 16 of the Constitution is a design option for dealing with the problem of abusive amendments and obviates the need for judicially created limits to amendments power like the basic structure doctrine. This is in line with the view expressed by Professor Rosaline Dixon and David Randau. My take home from this scholarly perspective is that tiered design of constitutional amendment process is one of the design options used to curbing the problem of hyper-amendments. Professor Rosanai rightly points out in his well-balanced amicus brief that the applicability of the basic structure doctrine depends very much on the context. The most important contextual consideration is the balance between flexibility and rigidity of the amendment process. The more difficult the amendment process, the less there is need for a doctrine of limits to amendment power. The jurisprudential underpinning of this view is that in a case where the amendment process is multi-stage, involves multiple institutions, is time-consuming, engenders inclusivity and participation by the people in deliberations over the merits of the proposed amendments, and as downstream veto by the people in the form of referendum, there is no need for judicially created implied limitations to amendments power through importation of the basic structure doctrine into a constitutional system before exhausting homegrown mechanisms. Moreover, I fully agree with a portion of the